Welcome to Strategy Saturday. I'm Charles Carillo, and today we're going to be discussing what are liquidated damages in real estate. Have you always wanted to invest in real estate but didn't have the time, didn't know where to find the deals, couldn't get the funding, and didn't want tenants calling you? Since 2006, I've been buying income-producing properties in great locations that provide us with consistent passive income while we wait for appreciation in the future and take advantage of tax laws while we're waiting. And unlike your financial advisor, we invest alongside our investors in every property we purchase. Check out investwithharborside.com. If you like the idea of investing in real estate, if you like the idea of passive income, partner with us at investwithharborside.com. That's investwithharborside.com. Liquidated damages refer to a predetermined amount that in case of non-performance of some or all obligations, the party in breach is required to pay the other party compensation. Liquidated damages are commonly used in construction and real estate agreements. Sometimes liquidated damages is a general term for clauses that allow the parties to specify a penalty if one party fails to perform any obligation under the contract. In others, it is a term that refers to clauses where both parties agree to a specific amount of money in the event of a breach of contract. So what are the benefits of a liquidated damages clause? Well, it forces a true commitment between the parties since there is now a consequence of having to pay liquidated damages to the other party after a breach. It allows all parties to understand their potential risk in the agreement if they were to breach it. It helps to avoid a possibly unfavorable judgment from a court on damages following a breach. It provides compensation for a party that was harmed because of another party's actions or inactions. It provides a realistic amount for damages in cases where it might be difficult to calculate the loss. And it provides a reasonable estimate of actual damages. What are the liquidated damages in real estate contracts? So within the realm of real estate contracts, liquidated damages clauses are a predetermined amount that one party must pay to the other party for failing to perform under the terms of the contract. Since it is difficult to place a value on a real estate contract, the liquidated damages clause is an efficient solution. Liquidated damages normally occur in a real estate contract because either party is unable or unwilling to complete the sale. Typically, when a party is buying or selling a property, once a contract is signed, they enter into other agreements and avoid other agreements because of the real estate contract they just signed. These other agreements may have costs involved with them. For example, a buyer orders a number of inspections and places a deposit with a contractor to make repairs once they close. Canceling these agreements will most likely cost the buyer money. Say you're a real estate investor and you locate a vacant lot that would be perfect for a self-storage complex. You put the property under contract, which includes a liquidated damages clause for $100,000. After the contract is signed, you speak to a self-storage developer who wants to purchase the lot from you, and you agree. You then sign a contract with the developer with a liquidated damages clause for $50,000, since the developer will be purchasing some of the materials immediately because it takes 3 months to receive them. Now the property owner then changes his mind, and because he wants to build the self-storage complex himself, and now the property owner disputes the liquidated damages terms with you, the investor, and you seek judgment in court. Now the judge chooses to only award the developer the $50,000 of liquidated damages because it is a more reasonable measure considering the actual expenses the developer incurred. You as the investor, they say, didn't incur any. So a lot of the liquidated damages clauses, if they're unreasonable, they will not be held up in court. So what are liquidated damages in construction contracts? Liquidated damages in construction contracts are designed to compensate a party that is adversely harmed by a contractor as a result of a breach contract. Liquidated damages are able to protect different portions of the contract, including construction defects, delays, and other failure to perform under the contract. In reverse, if a property owner was to not pay a contractor for the services they have provided under the terms of the contract, a contractor may place a construction lien on the property. For example, you are noticing minor leaks in your roof and you speak to a roofing contractor. They quote the job and the timeline for completion, which states the job will be completed before May 1st, which is right before the start of the rainy season. Since going past this date may cause further damage to your property, a $20,000 liquidated damages clause is added by you. The contractor disappears halfway through the project and you're unable to find another roofer before a large rainstorm occurs that causes major damage to your property. You, as a property owner, will most likely be able to enforce the $20,000 liquidated damages provision. Now, many states place limitations on the enforceability of a liquidated damages clause in a contract. In other words, the liquidated damages must be reasonable when accounting for the actual or anticipated harm caused by the breaching party. For example, if a party has $10,000 in actual losses under a contract and the liquidated damages clause states an amount of $100,000, it will be very difficult to enforce the full liquidated damages amount. Most courts will void unreasonable liquidated damages clauses. So I hope you enjoyed. Please remember to rate, review, subscribe, submit comments and potential show topics at globalinvestorspodcast.com. Look forward to 2 more episodes next week. See you then.
Nothing in this episode should be considered specific, personal, or professional advice. Any investment opportunities mentioned on this podcast are limited to accredited investors. Any investments will only be made with proper disclosure, subscription documentation, and are subject to all applicable laws. Please consult an appropriate tax, legal, real estate, financial, or business professional for individualized advice. Opinions of guests are their own. Information is not guaranteed. All investment strategies have the potential for profit or loss. The host is operating on behalf of Syndication Superstars, LLC exclusively.